Good morning, everyone. My phone now says it's 10 o'clock, so I'm going to open the webinar. People are hopefully now joining. I'm aware that sometimes it takes a little bit of time for everyone to sort of be let into the webinar, so I won't kick off just yet. I'll just give it a few moments, but on the basis that people are sort of drifting in and on the basis that we have limited time today, I think I will get going soon. So the offer today is that I will spend around about 30 minutes, maybe a little bit more, talking about expert evidence. But as you all know, that is a potentially huge topic. And so although I'm sorry to start with a caveat, I'm afraid that I cannot offer that it will be comprehensive. Rather, I want to leave you with some principles, some practical points, and some impressions that might be of some use. In slightly more structured terms, what I'll be talking about in the time we have is what is on this slide here. The first three bullet points are really a recap of some of the more fundamental principles. The fourth bullet points will be a practical recap of some of the key points from part 35. The fifth bullet points, like any topic concerning privilege, I will approach with some trepidation and nervousness. But I'm going to try and just give you three big takeaways from that. The sixth bullet point, hopefully a little bit lighter, reflects both some case law addressing good and bad expert evidence and my own experiences. Finally, I'll touch briefly on Griffiths and TUI, and then perhaps finally, and perhaps most usefully, leave you with some useful references and sources. So without further ado, let's get going. This slide poses a seemingly trite question, and the first bullet point provides an even more trite and obviously circular answer. But I think it is worth taking a moment to reflect on what we are talking about when we talk about expert evidence. So very obviously, expert evidence is evidence given by an expert, and we have it because in civil litigation, judges are the ultimate decision makers. They make findings of fact and apply the law to those facts. But if there is an issue, which is beyond the expertise of the judge to decide by reference to documentary evidence or factual witness evidence, or is an issue which is ultimately a matter of expert opinion, then judges require assistance from an expert to make the findings to decide the issues. That is what the quote here from Lord Hodge in Griffiths tries to encapsulate, or does encapsulate. And that leads to two takeaways that I would make at the outset. Firstly, expert evidence is not just opinion evidence. It can also be evidence of fact or fact and opinion, and is often, in fact, mixed evidence of fact and opinion. Secondly, even in cases where the issues are solely determined by reference to expert evidence, the experts still do not decide the cases, judges do, and that rings out true and clear in many of the authorities. And the final bullet point on this slide is also important for today's purposes. In this talk, I'm talking about part 35 experts. In other words, someone instructed to give expert evidence in connection with proceedings. So I'm not talking about an expert advisor who is instructed to give professional advice to a client in connection with a case. More in the background, you sometimes get that, but they're slightly different. We've addressed then briefly the first fundamental question, what is it? And so the second seemingly straightforward question is therefore, in what sorts of cases will you need it? We'll come on to relevant provisions of the CPR in a moment, but I'm sure you all know that you need permission for expert evidence and the court has a duty to control it. So the bullet points on this slide here provide something of a flow guide, I suppose, as to when a court is likely to grant permission for expert evidence. So firstly, is there an issue in the case requiring evidence of opinion or evidence of a technical or scientific nature? If yes, and if expert evidence is necessary to decide the issue, then clearly it will be needed and it will be allowed. But even if expert evidence is not necessary to decide the issue, would it nevertheless assist the judge in deciding an issue? So an example of that might be in a claim for loss of profits. Now, conceivably, that's something that you might be able to prove on the balance of probabilities from, say, cash flow forecasts, budgets, expected contracts, etc., or other such documents. But in a high-value case, it might be proportionate and assist the court to essentially have an expert who synthesises all of those documents and provides their opinion as to the most likely profit figures. This slide gives some examples of the types of cases in which it might be needed. Most obviously, very commonly, professional negligence cases, for example, claims of professional negligence by accountants, surveyors, architects, medical professionals, etc. The two caveats to that are in the bracket. So firstly, you don't need expert evidence for every allegation of professional negligence because, for example, the allegation may be simply that a tax filing deadline or something like that was simply missed. That doesn't require evidence as to the practice of the reasonable accountant. The second caveat to that, you don't need expert evidence when you are dealing with lawyers' negligence because judges generally consider themselves to be best placed to decide whether or not a lawyer has been negligent. Now, I'll use the word generally there because there is authority for the idea that legal practice in a particular area of law, perhaps cutting-edge transactional work or something like that, might warrant expert evidence as to what the practice in that area might be. So that's an instance when you might get it, but I think that's rarely seen. You could perhaps pose the question off the back of that notion, given the increasing specialism of the legal sector, does a judge with, say, only experience of civil or commercial law have sufficient experience as to what, say, the reasonable family solicitor would do? I had that in a case once. But for the moment, anyway, that is the law and the approach of the courts. Now, the other examples I've put there on the slide are, I think, fairly self-explanatory. When should you think about expert evidence? I'm using when here in the timing sense. And again, the trite answer to my question is as soon as possible. So in many of the cases I've talked about, it will be very obvious and probably obvious pre-action as to whether expert evidence is needed because it goes to a central issue in the case. In others, I think most commonly where it is needed for quantum, perhaps in a claim, because a claim is made for something like damages to be assessed, it is only after the close of pleadings that it may become clear that it is needed. So obviously, clearly, you should know after close of pleadings as to whether or not it be needed, but in some cases it will be obvious long before that. And in such an obvious case, I've posed the question here, should you get expert evidence before or after pleadings? Because partly inspired by this quote from Mr. Justice Coulson, as he then was in the commonly cited Pantelli case, he said here, essentially, how on earth could the claimant here, Pantelli, have asserted that this act was something that an ordinary professional would and should not have done if no professional in the same field had expressed such a view? Now, to be clear, the fatal issue for the claimant in Pantelli was that the claim had reached trial and there was no expert evidence had been to produce to support the allegations of professional negligence. That's why it's failed. So Pantelli is not authority for the suggestion you can't plead a case of, say, professional negligence without expert evidence. Ultimately, statements of case are signed by statements of truth that the signatory believes the facts to be true, not that they are known to be true. But, and I come back to the first bullet point here, it's nevertheless worth thinking about early because, especially sometimes in cases of professional negligence against non-lawyers and depending on the case and the field, it can sometimes be difficult to formulate a case, firstly, as to what the content of the duty a professional might owe is, and then to formulate breaches of that duty if you haven't had any expert input whatsoever at that stage. So it's something I think that could be thought about in some types of cases earlier on, and I think it can lead to a sort of a tighter and more well-drafted case. So those are some of the foundational principles about expert evidence. Now onto the CPR. I don't want to spend long on this really because, to be frank, you can all read Part 35. I just want to use these slides to signpost some of the key provisions in relation to expert evidence that are sort of the most useful ones. So on this slide here, 35.1, court has a general duty to restrict evidence to that which is reasonably required to resolve the proceedings. 35.2, experts owe their duties to the court and not their own clients. That's a very important principle and rings out in a lot of the cases and sometimes where experts go wrong. And 35.4, subpara 1, permission is needed for expert evidence, and ultimately the burden is on the party seeking permission to adduce it. Further part of subpara 2 of 35.4, this is a practical point, and it's sometimes overlooked, but if you are wanting to ask for expert evidence, and particularly if you're instructing counsel for a directions hearing or a CCMC, in principle you must provide an estimate of the costs of that evidence. The field, so subpara A, the fields and the issues which you will address, to some extent those are something that we as counsel can figure out with your assistance as solicitors from the pleadings and the sort of everything else about the case. But we can't estimate costs without making things up. So please remember that. And if you want expert evidence, come up with, go out and get an estimate. If you're doing a cost budget for a CCMC, then clearly that forces you to think about it. But especially in fast and intermediate track cases where there might not be cost budgeting, it can be more easily overlooked. To be clear as well, Part 35 talks about applications permission, but as I'm sure many of you know, it's actually very rare that it's done by way of a formal written application in the sense of filling out an N244 with supporting evidence, etc. Normally what you do is you say in your directions questionnaire, we'd like expert evidence on the following issues from an expert in the following field, and see whether or not the other side agree. If they don't, and it becomes a contested issue at, say, the CCMC, it's normally decided then by the judge without the need for a formal application. Effectively, it's made by way of oral application, I suppose. But if it is an issue, just make sure it's flagged up as such for any CCMC or directions hearing. I'm not today going to go into the issues around single joint experts versus each side having their own experts. In my experience, the courts, especially in lower value cases, love single joint experts, but they can often create hostages to fortune for your clients because you'd want to be reasonably confident that the expert is going to report more in your favour than the other side's. But clearly they are cheaper. And if it is not a key issue, say quantum, and you basically know the value is going to be in a range and the width of the range doesn't warrant the cost of each party having its own expert, then in those situations they might work better. As well as Part 35, the practice direction is both very useful and very important cross-check for the contents of an expert report in particular. Speaking as counsel and someone who occasionally has to cross-examine experts on the contents of their reports and make submissions on them, it's very easy fodder for us if the report in particular fails to comply with these two paragraphs. Subparagraph 6 to paragraph 3.2, which I put there and quoted, is often missed. If there's a range of opinion, and there normally is in any field, but your expert has pinned their colours to one mast without pointing out the other masts available, it's fairly easy to either get them to accept that they failed to point out the other masts, which amounts to immediate backtrack, or get them to look overly partisan by not budging an inch on their view. So do cross-check draft and final reports to the practice direction. Just some further sort of civil procedural provisions in relation to non-multi-track cases. Again, just in brief, the small claims track is far less prescriptive as to expert evidence, especially in terms of the form and contents. It's supposed to be more flexible, but there are restrictions on how much you can recover in the cost of any expert. The intermediate track, this is this new sort of track between the fast track and multi-track. Basically, the rules say you're not generally going to get more than one expert per party, and the reports shouldn't be more than 20 pages. But that's not hard and fast rules. And fast track, nearly always looking at a single joint expert on proportionality grounds. But I've put the references there so you can go away and check those if you've got a case in those tracks. Okay, deep breath now and dark waters ahead. Privilege and expert evidence. There are a lot of potential issues here and some potentially very complicated ones. I want to leave you with just three big takeaways and some things to have in mind so that an issue like this comes up, you might be able to just simply think, well, hang on, might need to think about this. There could be an issue here. Before I get to the first of the takeaways, two preliminary points to have in mind. Firstly, as a recap, litigation privilege protects disclosure of documents prepared for the dominant purpose of litigation, which is ongoing or reasonably in contemplation. Lots of case law around the meaning of dominant purpose and reasonably in contemplation, as you'd expect. But afraid, or perhaps not, we'd have time for that today. Secondly, in the context of this sort of privilege, we're talking about Part 35 experts instructed for the purposes of proceedings to give evidence. So again, not expert advisors. So with that in mind, the first takeaway, instructions to an expert are not privileged, but are not normally disclosable, provided that the report, like the expert report, states the substance of all material instructions. That's a requirement under CPR 35.10 subparagraph 3. If, though, there are suspicions that the report doesn't state the substance of all material instructions, so in other words, it's inaccurate or incomplete, you can apply for an order for disclosure of the instructions to the expert, and instructions is taken to mean all documents provided to the experts for them to produce their report, including privileged documents. So there's two real takeaways from that, I think. Firstly, be wary of providing experts with privileged material. And if you do, check whether or not their report refers to it. And if it does, whether or not that might amount to a waiver of privilege. It doesn't always, but it can do. So just bear that in mind. And secondly, draft the instructions to the expert carefully and make sure they're as neutral and proper as possible. Sometimes to ensure compliance with CPR 3510 subparagraph 3, the letter of instructions is appended to the report. That's not necessarily bad practice at all and can ensure it, but just make sure the instructions are carefully drafted. Second takeaway can be stated quite simply. Draft reports, so not the final reports, are nearly always subject to, and generally thought to be based following Jackson, thought to be subject to litigation privilege. But that then leads to the third takeaway, which is that if you get a very unfavourable expert report, either in final form or draft form, and the client perhaps says to you, right, clearly we need a new expert. Well, if you've obtained permission for your named expert and they've produced the report and you're seeking the court's permission for substitution of an expert, the court can't override privilege in the first expert's report, but they can order you to waive it as a condition for granting privilege, as a condition for granting permission to adduce expert from a different expert. What this is doing is discouraging the practice of shopping around for a more favourable expert opinion. There's actually nothing to stop expert shopping if it's at an early enough stage that there is no expert named in any court orders, although practically you should probably be wary of any expert who's too willing to be a gun for hire. But that's what the case or generally indicates, and that's generally what happens. If you do have an application for a change of expert, either you're facing one or need to bring one, I've referred there to the Avantage case, particular paragraph 17, which contains a really good summary of the principles. But I think these sorts of applications are fairly rare, so I'm not going to go through them, but you have the reference. So that's it. For me, those are the three big takeaways for my money on the topic of privilege and experts. A lot more could be said on this, and I think there are some really interesting issues that come up, but I'll leave it there for today. On to something hopefully a little bit lighter. I'm very aware that sometimes finding an expert able to produce a report in time and with a CV that would stand any sort of scrutiny is challenge enough. But in an ideal world, what makes, in my experience and by reference to the cases, the best type of expert? To start with, there are two very obvious, very big points. The first, and it sounds really obvious, but are they an expert? Perhaps more importantly, in the field and on the issue on which they're instructed to opine. It might seem surprising, but actually this is a relatively, or can be a common issue, and is certainly often a ground of for cross-examination. Quite a well-known case, recent case, is the Dasana case, where there was expert evidence, I think on both sides actually, from forensic accountants on the practice of demerger transactions. And the judge entirely disregarded it because the judge was not at all satisfied that either expert had sufficient experience of demerger transactions, even though they were forensic accountants. And there's a nice quote here from His Honour Judge Paul Matthews, which basically says, merely being an accountant for a long time does not mean you thereby become an expert in everything that accountants commonly do. As a former accountant myself, that certainly I can speak to that. But it seems very obvious. If you apply it to the medical sphere, you wouldn't ask an orthopaedic surgeon to opine on the work of a neurosurgeon, even though they're both surgeons. But probably in something like the accountancy sphere, it becomes a bit more blurred and it's more easy to slip up. So make sure your expert has practical experience in the area that they're being asked to opine on. The second big point, ensure that your expert doesn't have any conflicts of interest. This was a really stark case here, Essex County Council and UBB, and it'll be quite unusual. But in this case, it transpired at trial and presumably provided very fertile ground for cross-examination that I think it was the defendant's expert, UBB, had provided consultancy services to the company in the past and was himself potentially on the hook for a profit and egg claim if this case went badly for his client and the council won. And so the expert had a massive personal vested interest in defeating the claim. The upshot was that the judge did not exclude the evidence because this issue came out very late, but attached almost no weight for it because he considered the expert was entirely conflicted. So those are big and seemingly obvious points, and it's rare that you'll slip up on them. Here are some points of perhaps more subtlety, and I'll discuss these in the context of a case that I was involved in. Around this time last year, I was led on the second phase of a shareholder dispute. It was a Section 994 petition, but it went through arbitration, so I can only talk about the details of it to a limited extent. The second phase was entirely concerned with what was the fair value of this company in question. It's a 7-day hearing, all evidence was purely expert evidence. Now, the cases I've cited here and the quotes I've put were effectively quotes we put in our closing submissions, written closing submissions, and sought to use against the other side's expert. Firstly, this concept of real-world experience versus experience as a professional witness. Now, in this arbitration, certainly our expert did have experience of giving evidence as an expert witness, but it's fair to say that the vast bulk of his experience was in fact working as a valuer in the context of corporate deal activity. So we said someone who has got their hands dirty, adopting the language of the Sunrise Radio quote that I've put there. The other side's expert had what we said was less real-world experience, but far more experience, very impressive experience, but more experience as a professional witness. So in theory, if not always in practice, the courts do sometimes deprecate this breed of professional witness. It can be very difficult to challenge their expertise, and more of a subtle point, but if you look at a CV and the past 10, 20 years of their professional experience consists of just being an expert witness rather than a practicing professional in the field, there might be a point to be made. More easily, it's made as a point in conjunction with the second point I've made here on the slide, which is excessive partisanship, as I've described it. Now, this is a tricky one because clearly you want an expert who is able to robustly advance a position which supports your client's case. But when that is done in a way which strays over that fine line where suddenly they appear partisan, that's where perhaps you might be able to make points around them being excessively partisan. And how much can be made of this is all very much a question of degree. We use the quotes here on this case under excessive partisanship because they were actually about and describing the expert who we were against. So we were trying to paint a picture of this expert as being something of a hired gun in other cases as well as ours. But it's fair to note that in those cases, the court still accepted a lot of his evidence, and he was a very impressive and otherwise persuasive witness. So a lot of challenging expert evidence is sometimes, I think, about creating doubt in the judge's mind. Judges can be faced with impressive individuals who are highly qualified, and experts in a field which the judge is not. It takes intellectual courage and ability for a judge to see through that and to some extent put it to one side. And so sometimes what you need to do is be able to show them an alternative path to do that. And a lot of what this comes down to, and what makes the best expert, I think, is really trust. The court has to be able to trust that the expert is just that, an expert, is not conflicted, is practically experienced in their field, and is sufficiently objective in their evidence. And if the court can trust all of those things, then it's often very difficult for the court to do anything other than accept their evidence. So my own view as to what makes the best expert witness in court is that they should be a teacher and not a lecturer. What do I mean by that? Because you might well say, well, they're pretty much the same thing. What I mean is it goes back to that quote from Lord Hodge I put on one of the earlier slides. An expert is there to assist the court. They, through their reports and any oral evidence they give, are there to convey information. But ideally, you want an expert who can make what are often very complicated concepts seem simple. The expert we were against, so to speak, in the valuation case I talked about, was very good at this. We had a tribunal of 2 senior silks and a retired Court of Appeal judge. These were highly intelligent people, but they were grappling and in some cases struggling with complicated valuation concepts. Now and again, you could see the other side's expert enter into more of a conversational dialogue with the tribunal following a question they might ask. And he might put something in a very straightforward way, and you could see it was like a light bulb going off. And for the rest of the hearing, the tribunal might keep returning to that more simplified concept as a way of understanding what they were saying. In contrast, an expert who is perhaps brilliantly learned, but too professorial, too much of a lecturer, it's probably a little bit unfair on lecturers, but by nature, they generally stand at the front and talk, and sometimes lose a judge or tribunal. You want a teacher and a guide who it seems like is helping the court, not someone there who is simply lecturing them. Behind the scenes, that's what makes, I think, the best witness in court. Behind the scenes, you really want an expert who is able to help you to understand what the other expert is saying, what their best points are, what their weakest points are, what the areas of challenge might be. Finally, now, in the time we have left, I'm only going to touch on Griffiths and TUI quite briefly because there are some, to be honest, very good case notes and summaries out there if you want to know more about it. They've been produced recently because it's a very recent decision. My own view on this case is that it is in fact perhaps less about expert evidence per se and more about the requirements of a fair trial. So in a nutshell, in this case, Mr. Griffiths had uncontroverted evidence from an expert, which was not challenged by the other side until their closing submissions. So the expert, it was uncontroverted, and his evidence was not cross-examined on. I think it was a small claim, certainly very low value, so proportionately, that decision not to cross-examine may have seemed understandable. And I think it's common ground at all levels that the expert report of Professor Pennington was not particularly impressive and perhaps a little bit sparse on the reasoning. Essentially, at first instance, the judge said the court is not a rubber stamp. She accepted the challenges made to the report in closing submissions and dismissed the claim and said Mr. Griffiths has not proved his case on causation. That was appealed to the High Court, then the Court of Appeal, and then the Supreme Court. And interestingly, the Court of Appeal agreed with the first instance judge. They themselves were overturned by the Supreme Court. The Supreme Court basically said, no, you can't do what TUI did at first instance. If you're going to challenge any evidence, then the person who has produced that evidence needs to have been given an opportunity to respond, either in oral evidence or in the case of Part 35 questions, perhaps in the questions to the expert. And there's a powerful quote there, I think, from Lord Hodge, who basically cited from Phipson on evidence as to the requirements of a challenge to evidence, expert evidence at trial. But the takeaway from that is not, perhaps as some headlines might lead you to believe, that the court is bound to accept uncontroverted expert evidence. Firstly, because there are exceptions that you might be able to shoehorn your challenge into. Lord Hodge provided a list in Griffiths at paragraph 61-69. He describe those exceptions as non-exhaustive, so it's conceivable to think that there might be scope to argue for more, and I've listed them there. Second reason is because Lord Hodge made it very clear in Griffiths that despite the outcome in the instant case, the court is not a rubber stamp for uncontroverted evidence. It goes back to the quote I put from Lord Hodge right at the start of this talk. Court can accept challenges even to such evidence. You just need to put them in a fair manner. Clearly, that's not easy to do when there's no competing expert evidence to replace that evidence with, but it can be done. So practically, what I would say should be taken away from Griffiths really for most purposes are this. If you're going to mount a head-on challenge to expert evidence, either make sure you do it in cross-examination, but at the least, and ideally also in the questions to the expert, which you're allowed to put as part of Part 35. Don't challenge expert evidence, really any evidence, by ambush in closing submissions for the first time. Finally, because I think we are slightly over time, and I apologise for that. Perhaps the most important slide. This is a hopefully useful source list I've drawn up from this talk. And as I say, I'm going to circulate these slides after, so you'll have these as a reference point if they are useful. Most obviously, CPR Part 35, the practice direction, and the notes to the White Book are all really excellent source of information. And practical law, if you have access to it, I'm sure you use it. I think some barristers have a real squeamishness about admitting that they use it. But I unashamedly do, because especially in an area like this, which is a mix of practical points, law and procedure, there are some really good practice notes on it. And I've referred to a couple there, which I have drawn on as part of preparing this talk. Just don't cite them in court. If you want to do a deep dive on any of these issues, Phipson on Evidence is an excellent practitioner's text. Also, just to flag the court guides, I'm a really big fan of these. Now, certainly, if you are in these divisions of the High Court, they should be compulsory reading as to the approach that should be adopted with expert evidence. But in fact, the principles that they suggest are really useful, and I think they're often actually written in a really clear and helpful way. So even if you're not in the Chancery Division of the High Court, the paragraphs there in Chapter 9, I think are a really good sort of model as to how to approach expert evidence. Finally, yes, this is a shameless plug. I've put my email address there. Please feel free to use it and get in touch with me directly on any of the issues I've raised today. I don't particularly enjoy self-promotion, but my clerks would frankly kill me if I didn't mention this. In a past life, I did train and qualify as a chartered accountant. I didn't give expert evidence, and I wouldn't profess to be an expert, but I do have something of an insight into what it is like trying to translate concepts from the world of accountancy into the legal sphere, which does give me a real interest in this area. That's it. Thank you all very much for your time this morning. I hope it's been of some use or interest. I'm afraid I don't have time for questions today, but like I say, you've got my email. If there's anything you want to ask, if there's anything I haven't addressed, please do get in touch, but I hope that's been of use. Okay, I'm going to stop screen sharing now, and I'm going to end the webinar. Thank you all very much again.